too few cases. If we come back next year, we expect there'll be quite a number more because each year there are a lot more AIA patents being granted, which leads to more AIA patents being challenged. So why are these proceedings so popular? The reason they're popular is that they're much less expensive than patent litigation. Patent litigation in the United States is very expensive. As you can see on the slide, an average case is $2.5 to $3.5 million. It's going to take probably 2.5 years. The standard that's applied if you want to invalidate a patent at a court is clear and convincing evidence. In AIA proceeding, the average cost is still high. You'll see I've written $400,000 to $1 million. We've done some of them for substantially less than this, and as we'll discuss later, it's possible to settle these. So $400,000 is a low end if you go all the way through and pull out all the stops, but very many of these can be done for less. But still, you're going to spend something, just substantially less than the $2.5 to $3.5 million for patent litigation. The time to decision is much faster, 1.5 years instead of 2.5 years. And there's a difference in the standard of proof. So I said it's clear and convincing evidence for litigation. For an AIA proceeding, it's lower. You just have to meet a preponderance of the evidence. So in litigation, the patent's presumed valid and you have to overcome that presumption. At the Patent Office, there's no presumption, so whichever side is just barely above the other side will succeed. And a very major benefit to the challenger is the claim construction. There are some complicated rules of how a claim is supposed to be constructed in a court. Those rules aren't applied at the Patent Office in any of these AIA proceedings. Rather, it's the broadest reasonable construction. And if you're involved in patent prosecution in the United States, you'll know that the broadest reasonable interpretation very often is not really the broadest reasonable interpretation. It's the broadest possible interpretation. And you get very frustrated with the Patent Office because they come up with extremely broad interpretations. And if you have an extremely broad claim, you're not talking about any risk of infringement in an AIA proceeding. So having a broad interpretation is very valuable because it's a big target. And so you get this big target, and all you need is a preponderance of the evidence to knock it out. And so that's why you'll see that a very high percentage of all of these AIA proceedings have been successful. The percent success is much higher than the percent invalidation in a court. I think we'll skip this slide because it's getting into a level of detail that is beyond what we're at. But before I turn it over to Harnik, and who will speak about the nuts and bolts of how to carry out one of these proceedings, I wanted to talk about the broad strategy. IPRs are primarily used these days, but not exclusively, in a defensive sense. So when a party is challenged and sued under a patent, it's extremely common now to defensively go to the Patent Office and ask the Patent Office to invalidate the patent. The invalidity defense could be done at the court, but if you bring it to the Patent Office, as I mentioned, you have a higher likelihood of success. And so it's become extremely common that every time there's a lawsuit, there's a challenge to the patent at the Patent Office. But that's not the only way that you can use these proceedings. You can use them offensively too. You can use them to get rid of barrier patents. If you have a product you want to bring to market and there's a big patent of your competitor that you see that's in the way, you can create freedom to market by bringing one of these AIA proceedings. And even though it's expensive, maybe I said $400,000, that could sometimes be quite a bit less expensive than designing around the patent, spending time bringing all of your engineers to bear to redesign the patent redesign the product rather, to avoid the patent. So it's a cost-benefit analysis. It may very many times be cheaper to challenge the patent than to design around. It also could be leverage if you started talking to a party. Let's say you want a license to a particular patent, and the licensing negotiations start breaking down. At that point, you might say, well, you know what? If you're not willing to negotiate in good faith and provide us a licensing deal that is reasonable to both sides, we're going to file an IPR against this patent, and you don't know what's going to happen. You don't know what's going to come out the other end. So sometimes just that threat is enough. Sometimes actually filing it might lead to settlement. So it can be quite a valuable tool in that circumstance. There's also another use, and I was joking yesterday that I put this under the heading of offensive uses, but perhaps you might find this offensive, which is a slightly different word in English, meaning that it gives offense. But there are parties who will manipulate the financial markets by buying up a stock on a short sale basis, meaning that they make a big bet that the value of the company will go down. And so once they buy a short position in the stock, then they file an IPR on the key patent of that product, that company that they've just bought short. So the stock market goes down, the stock value goes down, and they've made a lot of money. So it's a legal way to manipulate the stock market. And perhaps Congress will step in and say this is not legal, but at least for now, the interpretation of the law is that the SEC won't come after you. I'm not recommending this approach, but it exists. So, just to give you some flavor of what's happening when you do file an IPR, if a petition is brought, about 3/4 of the time it's going to be instituted. And so if you're the patentee and you can stop the patent from being instituted in an IPR, you're going to be in good shape because it's very difficult to stop this. And then if it does get instituted, you can see what happens is that 70% of the time, all the claims in the IPR are found invalid. Only 14% of the time do all the claims survive. And about 85% of the time, you have at least some of the claims being invalidated. You'll also see this tiny sliver of 1%. And that tiny sliver is the percentage of cases where a motion to amend the claims was granted. So unlike oppositions in most other countries, if you're familiar with oppositions in most other countries, it's very common to amend the claims during an opposition. In the U.S. system, it's virtually impossible to get a motion to amend granted. So these claims are either going to be upheld as valid or found to be invalid. You're not going to amend them to preserve their validity unless you really have done everything right. So with that, I'm going to turn the podium over to Harnik, who will go over more of what really happens when you use these proceedings.
So now I'll walk you through a timeline of what a typical IPR goes through. And it's a relatively quick proceeding. So if you see from the timeline, from the date the petition is filed, you can expect to get a decision between 12 to 18 months. And what I'll do is, instead of going into too many details about each stage, we'll talk about the experience. This last year, we prepared about 10 to 15 IPRs against a single corporation, and it was a massive challenge. And one of the aspects, we actually ended up using Indian search firms quite a bit to prepare the petitions. So there are two parties involved. It's a petitioner and the patent owner. Petitioner is the one who's challenging a particular patent, and patent owner is obviously the owner of the patent. So as a petitioner, when you first decide this is a particular patent that I need to challenge, you pretty much get one shot at this. So think about your Angry Birds game, and if you're firing a shot, you want to go for the kill one such that the entire castle is destroyed and all the pigs are dead. So when you're preparing the petition, look at the claims and do a broad search, because there are estoppel issues. You might not get a chance again to go after the same patent. So your search needs to be extensive. Find all the relevant art that you can find, and then you need to cull it down and prepare a petition with your best arguments. You can have multiple grounds. Generally what we have found in our experience is to avoid anticipation ground, because anticipation, it's really easy for the patent owner to argue that this particular limitation is not shown in the prior art. So even though where we have cases where anticipation is so clear, we still go and use obviousness as our ground, because we found that that gets over the challenge and it gets likely to be instituted. So the biggest challenge that you have in the petition is the limit. So before, earlier last year, it used to be 60-page limit. And now it's become a word limit, and I think it's 14,000 words that you can have in a single petition. So you have to be very judicious with your resources. Do you want to include multiple grounds? So, if you have reference A and B, then do you also want to include C and D? We found the more grounds you have, the board might think that your position is weaker. And when you have multiple grounds for challenging, then you also have to show why you're including those multiple grounds. You have to show the strengths and weaknesses of them. So this stage is one of the most important stages for a petitioner in trying to come up with a single petition to knock down a patent. Sometimes, we had a couple of patents in our project where there were about 60 claims, and there's no way we can challenge 60 claims in 14,000 words. So in that case, you should pick certain claims or file multiple petitions. You can do that. So after you file the petition, the patent owner gets 3 months to respond. And as a patent owner, this is one of your best chances to argue while it should not be instituted, because as Dan showed the statistics, once it gets instituted, there's a high likelihood of chance of it being rejected in the final decision. And one of the reasons for that is the people who are deciding, the judges who are deciding for institution that there's a reasonable likelihood of invalidity, are the same judges who are writing a final decision. So if I'm already of the mindset that this patent is likely invalid, I'll probably it'll be hard to change the mind. So for a patent owner, this stage is really important to make sure you come up with the best arguments, show why it should not be instituted, and you can use one of the things that I didn't talk about in the petition stage is we generally always have an expert declaration. So try to find a really good expert, because this expert will be deposed, and you want to make sure that it's a credible expert. So as a patent owner, it's up to you if you want to use an expert as well, but it's not necessary. So now 6 months have elapsed from the filing of the petition, and this is when you get a decision from the board. It's a panel decision, and the decision basically just states whether it should be instituted on some grounds, all claims, some claims, and if they're instituting it, they'll generally borrow the reasoning from the petition itself. So once the IPR is instituted, then the patent owner gets a chance to respond to the institution, and now they can be more targeted, because before, in the patent owner preliminary response, you had to argue every single thing in the petition. But now you only argue the grounds or the claims that were instituted. And this is the best time to get evidence in the record too. So if one of the grounds that was instituted was an obviousness ground, then you want to get into record secondary evidence of non-obviousness, and you can do that by having your inventors or any other way like marketing. So this is your best way to get evidence in the record. The next stage is pretty much discovery. Which I'll talk about in the next couple of slides. And leads to the oral hearing and written decision. So the whole process is very fast. Most IPRs actually don't end up going through all these processing. The cost that Dan mentioned, about $500,000, that's for like a complete IPR. It could go to $1 million, but the petition stage is about $50,000 to $100,000 to prepare a petition and filing it. So as I mentioned while going through the slides, it's really important to think about the end goal very early, because as a petitioner, you only get one chance. And there's a lot of technical constraints, like the number of words and what you can do. And that's why it's really important to think about what will be your best arguments and have a focused story. We often use a team approach where we need IPR Deputation. It's like a legal brief, right? The way we think about it is like a summary judgment motion, because you're making it argumentative. And our team generally consists of, we have litigation and prosecution, so someone who has a deep understanding of technology, but at the same time can be persuasive in their arguments. As I mentioned, a lot of IPRs get settled, and one of the reasons it's one way to avoid estoppel. If it gets settled, then there is no estoppel, and you can file future IPRs. But the issue with settlement is if you do it too late in that timeline, so let's say all the briefing is done, the oral hearing is done, then the board may just decide to keep going on the IPR because everything has been briefed. So even if you settle, there's a risk of your patent being invalidated by the board. Estoppel, as the case law is still in flux, but one of the important things is the grounds that are denied as redundant. So as I mentioned, you can argue multiple grounds, and if the board had selected just the first ground, then you can go back again and use a second ground. So now we'll just go through some of the statistics. I know the nuts and bolts were technically heavy, and if you have more questions, feel free to ask me after the talk. And as you can see, it's exploded from 2012 to 2016. We're leveling off now, where I think by end of 2016 we'll have the same number of IPRs, the inter-party review being filed. This is a breakdown of the technology sector. There's been a large number of IPRs in the electrical and computer area, and there's been a significant increase in the biotech area as well, with pharmaceutical patents being targeted by companies like hedge funds and generics as well. So this is the overall trial institution rate that Dan had showed earlier. As you can see, 56% of the times it was instituted. That number has gone down a little bit in 2016, but it's still relatively high, and more than half the challenges are being instituted. So that's why filing a petition puts the patent owner in a dire situation, if you want to call it that. So this is more particular to the life science area, where you can see an institution rate of 51%. So as I mentioned earlier, a large number of these get settled because of the high rate of rejection in the final decision. As you saw, if it goes all the way to the final written decision, 70% of these patents are getting invalidated. So as a patent owner, you have incentive to settle this case earlier. And that's why 45% of these get settled. Sometimes you seek an adverse judgment. When you seek it's a little bit more technical, and we won't go into too much detail, but as a patent owner, you may want to seek an adverse judgment on some claims so that your other claims can survive. So these are life science final written decisions. 63% are getting invalidated. And just coming up with the conclusion, so as Dan started, our panel topic was creating new value, and one of the ways to create new value is by destroying old value, and that's what's happening in the U.S. with the patent protection getting weaker with 101 and this AIA review. So although the cost is relatively high for an IPR, like I mentioned, just filing a petition is a big threat, and the cost of filing that is about $100,000, which is cheaper than sometimes doing design rounds or going for a declaratory judgment at a district court. And you may not want to wait to be sued because that's a risky proposition. So here is our conclusion, and now I think we'll be ready for questions after this. Thank you.